It covers human rights issues, particularly women's rights, access to justice, as well as sexual and gender-based violence, amongst many, many others. So we are held by a lot of experience and so excited to have her today. Wele, thank you so much for speaking to us today. And I'm looking forward to this amazing presentation you have for us. I'm going to hand over to you and welcome to today's session.
Thank you very much, Lynn. Good afternoon, everyone. As you've heard, I am Welekazi Stofile from Tshwaranang Legal Advocacy Center, a women's rights organization, which is also part of the Call to Action Collective. Today, I'm going to be facilitating a session focusing on the passing of laws in South Africa. The reason why we have this session as part of the 12-week program that we are currently having as the Call to Action Collective is to ensure that we are all on the same page in as far as legislating the NSP. The NSP, which is the National Strategic Plan on Gender-Based Violence and Femicide. You would have heard during the past few weeks when Sbongile was talking about the institutional arrangements and the implementation modalities of the National Strategic Plan. It is provided under Chapter 5 that the Department of Justice and Constitutional Development is supposed to draft a legislation that will set up the powers and functions of the National Council on Gender-Based Violence and Femicide. So before I kickstart this session, I'm going to just take you through the outline of what I will cover today, so that we are all on the same page in as far as that is concerned. So we are going to look at the objectives of this particular seminar, and then from there look at the difference between a law, a bill, and a policy, and also move to the constitutional provisions for passing of laws in South Africa, and also cover the law reform process at national level as well as at the provincial level and the local level, which is the level that covers municipalities or municipal councils. But by the end of this session, we hope that we will all be able to understand the instances that give rise to the need for a passing of a new law or amendment of an existing law or repeal of an old law. We are also going to focus on the, as I said, law reform or lawmaking processes in South Africa, as well as opportunities for engagement during the lawmaking process. I am having a challenge with moving my slide. Maybe Dabu can step in there. Yeah, okay. All right. Now, a law is a system of rules usually enforced through a set of institutions to regulate human conduct. A law shapes politics or economics of a country, or it also shapes the way we conduct each other or interact with each other as members of a society. A bill is a draft version of the law, and we cannot call an act a bill when it has been passed. What I'm saying here is that the Constitution of 1996 is an act of Parliament. So when talking about the Constitution, we cannot refer to it as a bill because it is no longer a draft version of a particular law. It has gone through the processes and was enacted in 1996 and it became law. Now, for a bill to become law, first it must be approved by the cabinet before the relevant minister or deputy minister or committee introduces it to Parliament. Now, a policy like the National Strategic Plan on Gender-Based Violence and Femicide is a document which merely outlines what a government ministry or department hopes to achieve. And it includes methods and principles that will be used to achieve that which it sets to achieve. Now, in terms of the Constitution of the Republic of South Africa, that document grants powers to Parliament to pass new laws, amend existing laws, or even to repeal old laws, as I said earlier. It also gives powers to provincial legislatures in the 9 provinces of South Africa to pass provincial laws. And it also gives municipal councils at local level a responsibility or a power to enact municipal bylaws. And which provisions of the Constitution are these? If you look at the Constitution under Section 42(1), and that section gives the power to both the National Assembly and the National Council of Provinces to participate in a legislative process. Now, when we talk about Parliament, we are definitely, of course, talking about these 2 houses of Parliament, that is the National Assembly and the National Council of Provinces. Then under Section 44, from Section 44(1)(a)(b) moving forward, you will find that powers are conferred on the National Assembly to pass legislation, whereas 44(1)(b) grants powers to the National Council of Provinces to pass legislation, but not only to pass legislation, but to also participate in the amendment of the actual Constitution. When you look at the constitutional provisions, you tend to see that there is a division of powers between the national level, provincial level, and local level, and also between the National Council of Provinces and the National Assembly itself. So Section 44(2) allows Parliament to intervene and pass a law in terms of Section 76 on matters that are falling under Schedule 5 of the Constitution, particularly if those matters are related to national security or maintaining of economic unity, etc., etc. As I proceed with this presentation, I'm going to go into detail in terms of what laws can be passed under Section 76 and what matters are provided for under Schedule 4 or 5 of the Constitution. Also, Section 44(3) talks about the Parliament having the power to pass legislation on any matters that are reasonable, necessary to effectively exercise powers concerning Schedule 4. And as I said, I'll give you examples of what matters can be legislated at both these schedules, whether it's Schedule 4 or Schedule 5. Chapter 6, under Section 104 of the Constitution, deals, as I said, with the legislative authority of provinces. Remember earlier I said that even provinces, through their provincial legislatures, they may legislate on certain issues that are spelled out in the Constitution. And interestingly, provinces may pass a constitution for their own province. They may also pass laws that are in line with their functional areas as provided for in Schedule 4 and 5. And in instances where they have identified a need for a piece of legislation and they are unable to pass it at the provincial level because they do not have an authority to do so, they may, in those instances, recommend to the National Assembly that a particular legislation be passed. Now, Section 156 provides for municipalities to make or amend bylaws that will enable them to effectively administer those matters that they have a right to administer. And then Section 172 deals with the powers of the courts in terms of constitutional. When you are looking at Section 172, you realize that actually before that section, there's Section 170 that talks about which courts into or rule on constitutionality of any legislation. And Section 170 says that courts of lower status, that is magistrate courts, district courts, or regional courts, they may not be into or rule on the constitutionality of any legislation, save for the High Court moving forward to the Supreme Court of Appeal, as well as the Constitutional Court. If we now turn to the schedules that I mentioned before, under Schedule 4, you will find that the functional areas that are listed there are those where there is a concurrent national and provincial legislative competence. What that means is this: the national legislature as well as the provincial legislature may pass a law for any of those functional areas that are listed under Schedule 4. Whereas Schedule 5 lists the functional areas that only have an exclusive provincial legislative competence, meaning that under Schedule 5, you'll find that what is provided for may be enacted at a provincial level or even at the municipal level, which is examples of matters that are provided for under Schedule 4, but they would be issues that pertain to agriculture, casinos, environment, housing, etc., etc. And under Part B of Schedule 4, those matters would relate to air pollution, childcare facilities, and local tourism. All of this information is found actually towards the back of your constitution. I've just picked up a few, but there is a much longer list that you can find. Then under Schedule 5, Part A, matters that may be legislated exclusively at provincial level relate to abattoirs, ambulance services, liquor licenses, etc. And I think we know that there are provincial, there are provinces that have enacted provincial liquor acts, like the Northern Cape, the Gauteng, and many others, I think Mpumalanga as well, and many others. So as an example, that to say we have indeed seen provinces enacting laws. And then under Part B of Schedule 5, issues like or matters relating to beaches, amusement facilities, control of public nuisances, etc., they can be legislated at that level. All right. Now, according to the Constitution, there are 4 types of bills that may be passed, and each one is provided for under these sections that you see in front of you. For instance, bills that deal with amending of the Constitution are provided for under Section 74 of the Constitution, meaning that they are dealt with right from when they are introduced to when they are passed. They are dealt with under that section of the Constitution. And then ordinary bills that are not affecting provinces are dealt with under Section 75 of the Constitution, and ordinary bills that affect provinces are dealt with under Section 76, and money bills that deal with appropriations, taxes, levies, or duties are dealt with under Section 77. Then in Section 79, that is the section that deals with assenting and signing off of a bill by the president for it to become law or an act of parliament. We're going to, as I said again, go into detail in terms of what happens after a bill has been signed into law. But at this stage, I am going to allow for a poll to take place, and I will see you right after that period. And I wish to encourage you to participate in that poll. Thank you very much. Welcome back, and thank you very much for participating in that poll. And now we are going to look at instances where a new law may be introduced. And we have a few examples where this happens. The first example is when a country has signed and ratified a convention, an international treaty or instrument. And an example that I am sharing with you here is that of the Convention on Elimination of All Forms of Discrimination Against Women, the CEDAW, which is a UN treaty. South Africa ratified this treaty and deposited the instruments of ratification to the United Nations. And after doing that, they needed to domesticate it. And that was done through passing of various laws. And I'm just going to mention the PEPUDA, the Promotion of Equality and Prevention of Unfair Discrimination. So that law and many others were passed in order to domesticate and implement the CEDAW Treaty. The second one is a regional one, that is the protocol to the African Charter on Human and People's Rights on the Rights of Women in Africa, commonly known as the Maputo. Now, this one is a 2003 protocol, which was signed and ratified by South Africa in 2004, and they deposited the instruments of ratification in 2005. Deposited those instruments with the African Union because this is a regional treaty. Now, by the time this treaty came into being in 2003, South Africa already had its constitution. So many of the provisions of that treaty are catered for in the Bill of Rights in Chapter 2 of our Constitution, but there are those that had to be provided for through enactment or passing of pieces of legislation. But even then, there are those that still remain, and I'm going to share examples of which articles have not been provided for or domesticated to ensure full domestication of this Maputo Protocol. For instance, if you look at Article 5 that deals with elimination of harmful practices, I can safely say that we have a harmful practice in South Africa, and that practice would be the practice of ukutwala. We know that we have no law that specifically deals with ukutwala in South Africa, but we do have a document that was prepared by the South African Law Reform Commission looking at this culture of practice of ukutwala. Another article that I may want to mention is Article 20 that deals with widows' rights, or Article 21 that deals with the right to inheritance, Article 22 for special protection of elderly women. As much as we have a law on older persons, we don't have a law that specifically deals with issues that affect elderly women or issues that affect women with disabilities or women in distress. So these are some of the examples that point to the fact that the Maputo Protocol has been domesticated to a certain extent, but not. And then another instance where it may be necessary to pass a new law is when a court has decided on a matter based on the on Section 172 of the Constitution, and enables them to actually make certain orders on issues of constitutionality or validity. The three examples that I'm going to briefly discuss to emphasize this point are the case of S versus Masia. And this case actually started in Sabi Magistrate Court in Mpumalanga, and then it was moved to Sabi Regional Court. This was a case of a 44-year-old man who had been charged with wrongfully and unlawfully having a sexual intercourse with a 9-year-old girl without her consent. the sexual intercourse was done anally. So the 9-year-old was penetrated anally. So this man was charged with rape, despite the fact that at the time, our common law definition of rape did not include anal penetration. And despite that, the man was convicted of rape, and then the matter was transferred to the High Court for sentencing. So he appealed both the conviction and sentence, and the matter went all the way up to the Constitutional Court. And the Constitutional Court decided to extend the common law definition of rape to include acts of non-consensual sexual penetration of a penis into the anus of a female. The reason why this was done is that at the time, the common law definition of rape did not, as I said, include anal penetration. So when a person was penetrated anally, that would be considered as indecent assault. And that is why the Constitutional Court then ordered that the common law definition should be extended. And this has resulted actually in the Sexual Offences Act of 2007. And the second case that I would like to briefly mention here is the case of S versus Mshumpa in the East London High Court. And this one relates to the killing of an unborn child. In this case, the boyfriend of this person, Mr. Best, colluded with Mr. Mshumpa to kill the unborn child. So in this instance, a third party, that is Mr. Mshumpa, shot this pregnant lady twice in the stomach. And then the prosecutor charged Mshumpa and Mr. Best with murder, despite the fact that the common law definition of murder does not recognize unborn children as legal subject of constitutional rights. And in this instance, the courts or the judge felt that this matter was best dealt with by the legislature, that the legislature will have to introduce a law that criminalizes the third-party killing of unborn children. So this one has not led to any passing of a law. It was just said at the time, and up to now, we have not seen any law that deals with the issue of the killing of the unborn child. And I'm sure as we are speaking, you are thinking about the many cases that we've been reading and hearing about in South Africa, where pregnant women have been killed, whether they were targeted or the child was targeted. The third one is the Teddy Bear Clinic case that is related to the Sexual Offences Act of 2007, and in particular, it was challenging two sections. Section 15 of the Sexual Offences Act that dealt with acts of sexual penetration between children of a certain age or between children of a certain age and an adult, as well as acts of sexual violation. These two sections were challenged, and the matter was heard at the Constitutional Court, and indeed the Constitutional Court agreed with the lower courts that section 15 and 16 were unconstitutional and as such were inconsistent with the Constitution and as such invalid. And again here, that the legislature was given 18 months within which to address this challenge. So the Sexual Offences Act was amended indeed to take into consideration what the court said. Moving on. Now, also in South Africa, the SA Law Reform Commission or a ministry or department may come up with a discussion document called a green paper to deal with a particular issue. And that will be published for comments. And once comments are received and are incorporated, a more refined version will then be developed and it will be called a white paper. and that white paper will be shared with the ministry that may be commissioned. It's a study for further discussions, input, and final decision. And once it is finalized, then it will be turned into a bill. Now, who can introduce a bill in Parliament in South Africa? A minister, deputy minister, or individual member of Parliament who is in the National Assembly, or a committee. And who can introduce a bill in the National Council of Provinces? It could be a committee or an individual member of the National Council of Provinces. And at the provincial level, who can introduce a bill in the provincial legislature? And that could be the member of the Executive Council, an MEC for whatever portfolio can introduce a bill, but also an MPF, and these are members of the provincial legislature. Now, a bill is normally drafted by the relevant department and submitted to the minister to submit it to the cabinet for its approval to be submitted to Parliament. And before it is submitted in Parliament, the state law advisors must certify that that draft bill is constitutionally sound before it is introduced in Parliament, and they must issue a certificate. They must issue a certificate of certification. Then after that, it must be tagged. The tagging is a process of classifying a bill into one of the 4 types that I mentioned before, and this happens after it has been introduced in Parliament. And the reason why it is tagged, it is to ensure that the procedure that will be followed is in line with the nature of this. Now, the tagging is done by a committee. It's called joint tagging mechanism, and that joint tagging mechanism consists of the Speaker and the Deputy Speaker of the National Assembly, chairperson and the permanent deputy chairperson of the National Council of Provinces. Once that has happened, then the bill is referred. Once that happens, then the bill is referred to the relevant portfolio committee for consideration. There are various portfolio committees in South Africa. I can think about the portfolio of justice, the portfolio of police, and many, many others. So after it's been referred here, that's when it is published for public comments, particularly if it is a bill of a public interest. It is published for written and oral submissions, or even for both. Sometimes written submissions are made, sometimes written are followed by oral submissions, and organizations are invited to go and present what they have written. After the deliberation and consideration submitted, it is submitted to the National Assembly for the second reading and vote. And if it is passed by the National Assembly, it then goes to the National Council of Provinces for consideration. Now, I'm going to then go through the processes that are followed when a bill under one of the 4 types is introduced in Parliament. The first bills that I'm going to cover are those that deal with amending the Constitution. If the bill is proposing an amendment to the Constitution, it then is dealt with under Section 74. And if it affects changes to the basic values of the Constitution, it requires a supporting vote of at least 75% of the members of the National Assembly and at least 6 provinces in the NCOP for it to be passed. If it is proposing changes to the Bill of Rights, found under Chapter 2 of the Constitution, it will require a supporting vote of at least 2/3 of the members of the National Assembly, and also at least 6 provinces that are in the National Council of Provinces in order for it to be passed. Now, a bill that is concerning a particular province or more than one province may not be passed by the National Council of Provinces unless it has been approved by the legislature or legislatures of the provinces concerned. For instance, if a bill that is concerning Gauteng is tabled in Parliament, the NCOP has to ensure that the Gauteng Provincial Legislature has approved that bill. Now, the Section 75 bills, and as I said, these are ordinary bills not affecting the province. So once an ordinary bill that does not affect a province has been passed by the National Assembly, it is then referred to the National Council of Provinces to pass it, and they may pass it subject to amendments, or they may just reject it completely. If the council passes the bill without proposing any amendments to it, it is then submitted to the president for assenting to it. If, however, it is passed with proposed amendments, or if it is rejected by the National Council of Provinces, it goes back to the National Assembly for consideration. The National Assembly may pass it with or without the National Council of Provinces proposed amendments, or they may just decide to proceed with the bill, or they may just decide not to proceed with the bill. The point here is that the National Assembly for a Section 75 bill may just pass it, even if the National Council of Provinces is not in agreement or is not supporting that particular bill. Now, once the bill under Section 75 has been passed by the National Assembly, again, it is submitted to the President for assenting to it. Section 76 bills, these are ordinary bills that are now affecting the provinces. Remember, under Section 75, it is those bills that do not affect the provinces. So once an ordinary bill that affects the provinces has been passed by the National Assembly, it must be referred to the National Council of Provinces. The National Council of Provinces must pass that bill, and they may pass it as it is, or they may pass it with some amendments, or they may even reject it. If it is passed by the council without any amendments, it then goes straight to the president again for signature. But if it is passed with an amendment, it goes back to the National Assembly for the National Assembly to look at the proposed amendments, and they may pass it, and if they have passed it, then it goes to the president again for the signature. So clearly here, the president is the last person to conclude the process of law making or law passing in South Africa. If the council rejects a bill, or if the National Assembly refuses to pass the amended bill, the matter must be referred to the Mediation Committee. Remember, in Section 75, I did not make mention of the Mediation Committee because the bills that are dealt with under Section 75 are bills that do not affect provinces. Whereas here, we are talking about bills that are affecting provinces. So clearly here, the National Assembly cannot proceed and pass that bill without, even though the NCOP is not in agreement. Hence, that bill would have, or the matter that is disputed would have to be dealt with by the Mediation Committee. But if the Mediation Committee is unable to show an agreement between the two houses of Parliament within 30 days, the bill may be passed by the National Assembly, but with a 2/3 majority. If the committee is unable to secure an agreement on a bill that was introduced in the NCOP, the bill lapses. Signing a bill into law. A bill is referred to the President after it has passed through the two houses, that is the NA, National Assembly, and the NCOP, to assent and sign it into law. But if the President, despite the fact that this particular bill has been passed by the two houses, if the President has reservations about the constitutionality of this bill, then they may refer it back to the National Assembly for reconsideration. And if it affects provinces, the NCOP must participate in its reconsideration. Once satisfied with the reconsidered bill, the President must sign it. But if the reconsidered bill does not fully accommodate the President's reservations, the President can then refer it to the Constitutional Court for a decision on its constitutionality. If the Constitutional Court decides that the bill is constitutional, then the President must sign it. Once the bill has been assented to and signed by the President, it then becomes an Act of Parliament and must be published in the Government Gazette. A Government Gazette that you find when you go to the government printing works. Many years ago, you could even go and buy a hard copy of an act, but I've noticed now that many acts are found in the government department's website, in places like the Parliamentary Monitoring Group or Stofile. So there are many sources now where we can find a signed piece of legislation or act of Parliament. Now, an act takes effect when it is published in the Government Gazette or on a date determined in it, meaning that it will have a date within which it will come into effect. An act requires certain actions to be taken by the responsible government department before it can be implemented. For instance, you'll find that an act has been implemented until regulations have been drafted and published for comments and finalized. And regulations or determinations or rules, they tend to further unpack what is in the act, because the act will be high level. You realize that when you read that act, there is a need for forms that must be designed and also clarity on where these forms will be submitted once completed. I'm thinking, like for instance, the Domestic Violence Act. If you read the act, you realize that there are certain documents that are needed for one to apply for a protection order, and there are documents that are needed at the police station and at the courts. So the regulations would then deal with those issues and even have those forms, which you would then complete, meaning that you cannot have your own form to complete to apply for whatever is provided for in the act. So once the regulations are finalized, the President puts the act into operation, and this is done through a proclamation published in the Government Gazette. Sometimes you find that this piece of legislation or this act has certain sections of it that are not implemented, meaning that sometimes you find that an act is implemented incrementally. I can think of the Sexual Offences Act. There's a certain section there that has not been implemented, and if my memory serves me right, even last year, the Department of Justice was busy drafting regulations to give effect to that particular section. So that happens also sometimes, which means that when an act is passed, one needs to be familiar with it to make sure that all the sections are being implemented at the same time, or also identify which ones are not being implemented. Now, lastly, I'm going to just briefly cover legislative processes at provincial level. And as I said earlier, provincial legislatures have powers to consider, pass, amend, or reject any bills that are placed before them. And they may also prepare legislation except money bills. When it comes to money bills at provincial level, those ones cannot be initiated by any other person other than the MEC responsible for financial matters. The MEC is the only one who may introduce a money bill in the provincial legislature. Again, once the bill has gone through the demarches and it has been passed, it then also goes to the premier of that province to assent it and sign it into a provincial legislation. And the processes will be the same, including the processes of where it is kept and what happens in the case where there's a conflict between a provincial and the national legislation. That information is also found in the Constitution, even where acts are being kept, the signed copies. Now, at local level, the local level is the municipal level, that is the municipal council. Section 156(1)(a) says that a municipality may administer local government matters that are found in Part B and made mention of earlier. Section 156(1)(2) also says that a municipality may make or administer bylaws. And there are examples of bylaws I'm sure you are thinking of at your local level, bylaws pertaining to cars, bylaws pertaining to access to beaches, bylaws pertaining to what we do in the streets, etc., etc. And then section 164(a) says that no bylaw may be passed unless all members of the municipal council have been given reasonable notice before that bylaw is passed. So this is some sort of a protection measure. And then section 164(b) says that proposed bylaws have to be published for comment before they are bylaws, before they are considered to be having any authority or power at that municipal level. And I have come to the end of my session and presentation, so I'm going to hand over to Lynn to check if there are any questions. And thank you very much.
Thank you so much, Wele, presentation. I think you really took the time to take us through quite detailedly, one by one, how the process works from the beginning to the end, both national and provincial level. I'll start with the first question that I have, which comes to us from the GoTo webinar. And that question, which comes from Tsigi, Tsigi wants to know, at which point can the public make inputs into the laws in South Africa?
Thank you, Lynn. Can you hear me?
Yes, Wele, we can hear you loud and clear.
All right, thank you very much. Thank you for that question. There are various opportunities where individuals or members of the public can make inputs into the law reform process in South Africa. Sometimes we get more than one chance. For instance, you may recall that the Department of Justice published 3 pieces of legislation that deal with sexual offenses, domestic violence, and they published those and called for comment from us. And before those were taken to Parliament. And again, they will be published for comment. So sometimes we can be invited at the department level before that draft bill even makes its way to Parliament. And again, in Parliament, we are invited to make, as I said, written submissions and sometimes oral submissions, and in some instances, both. So there are many opportunities, even at provincial level. I've also heard where communities are brought together to be asked to make comments on a piece of legislation at the provincial level or even national level, where the NCOP around the country, many opportunities that we have to contribute to a law reform process in our country. Thanks, Lynn.
Thanks so much, Wele. So basically, I think what I'm hearing from you as well is that even when this policy then starts, going through that process, there'll be lots of opportunities both at a national and a provincial level where we will have opportunities to comment. Am I right in assuming so?
Yes, definitely. I think there has been actually cases that have found their way to the constitutional, where certain laws were declared actually unconstitutional or invalid because there was no public consultation. I'm thinking actually, even when it comes to issues of mining in communities, there has been instances in the Eastern Cape, in Kolobeni, and in Northwest, where communities have gone to the Constitutional Court to challenge the Department of Minerals and said, you did not consult widely with us. You may have come and held a meeting with a few people, but that cannot be interpreted as consultation. So the point I'm making is that consultation is provided for in our law and it has to happen. So what we need to do as organizations working on these issues is to always be on the lookout. And I've seen that we also share information. When we come across a bill that has been published and public comments are called, we share that information. Like currently there's even I think it's a victim services bill with the closing date sometime in October, in September. Thank you.
Okay, great. No, thank you so much, Wele. I think that's quite clear, just how important that we also take part in that process as part of owning the process as well, and making sure that it reflects what we need and what we want, and not go through a process where it becomes a law that is no longer working for us. Right. Okay, I think I have another question for you, Wele. Just linking it back to the National Strategic Plan on Gender-Based Violence and Femicide, the NSPGBF. Why is this lawmaking process relevant to us? Can you say a little bit more about that?
Yeah. It is relevant, Lynn, in that right now we have a policy that spells out what needs to happen to move the fight on gender-based violence and femicide forward in South Africa. So if we want this policy to have teeth, it is necessary for us to make sure that the important or critical aspects of it are legislated. That will spell out expectations for us and other people. It will enable us to know what is it that we are going to be expecting, for instance, from the National Council on Gender-Based Violence and Femicide. It will not be like any other policy that has come and gone or that has gathered dust in a shelf somewhere. If this aspect is legislated, then everybody will be clear from the onset in terms of what will be the function of this structure, who can be a party to this structure, what will happen when someone who's a member of this structure has done ABCD, who is eligible, who is not eligible. Yeah.
Great. I think that makes it very clear to us. And then the next question that I have for us is, why should we want this policy to become law?
As I said, we want it to become law because we want it to have teeth. We want to be able to use something to hold people accountable. We want to be clear in terms of who's responsible for what. We want to know which department is responsible for which area of this policy. And we want to know what it is that we can do when certain things are not happening or not done. So it is quite important because as it is now, as I said, it is just a policy. It's not an act of parliament. It's not a law. It does not have the details that we would want to see in a piece of legislation.
Thank you so much, Wele, just for that emphasis of why it's so important and how that, ties into its implementation and actually how we then are able to engage with it as the citizens of the country. Wele, I have another question here from Bantu. I'm not sure if Bantu is asking this specifically to your organization, but I guess maybe it's a broad question that organizations that basically deal with workshops on government processes. Bantu wants to know, how often do you run workshops on South African laws, more especially for local government municipalities and or local forums? So maybe I think you could answer that as TLAC, as Tshwaranang Legal Advocacy Center. Thanks, Wele.
Thank you, Bantu, for that question. We work as an organization now as Tshwaranang Legal Advocacy Center. We work in 5 provinces, and in those provinces, we work with committee structures. And we have, for the past 20-something odd years, have been engaged in capacity enhancement of duty bearers and committee structures, community-based organizations, women, girls, and even learners in schools. We do work with municipalities or traditional justice systems, but only in the provinces where we work.
Okay, thank you so much.
That answers the question, but of course, if he wants to get in touch with us and get more information, he can do so through our website.
I also hope that that satisfies. Hopefully, if Bantu is listening and they have further questions or comments to that, they are going to respond maybe and ask a bit more. I think that would be all. I think that would be all the questions that I have from my side. Wele, is there anything else maybe, because your questionnaire had a lot, your presentation had a lot of meat in it. It was very meaty. And that's a good thing. But maybe there's something within there that you would love for people to, if there's nothing else that someone heard, if there's one thing or 2 things you want them to take away from your presentation, that is absolutely key. And maybe it's something that, you often get asked in this line of work over and over again around understanding the legislative processes of this country. What would you like to leave us with today?
Thank you, Lynn, for that. I would like to urge activists in the social justice sector to actually seek information, familiarize themselves with the provisions in the Constitution. And maybe if you have not been doing that, after this session, just go and pull out your Constitution and look for or look at the sections that I covered today, and even go to the schedules that are there at the back. Secondly, I also would like to encourage us as activists and as citizens to really be involved and take part in law reform processes, because by so doing, we have an opportunity to share our lived realities in the shaping of the law. It is an opportunity for us to engage with what is being done to ensure that it is a law that caters for our needs as communities. And I would also say, as I said, there are about 3 or 4 bills right now that require us to interrogate and contribute to ensure that the final product caters for what we would like to see to end gender-based violence and femicide in South Africa. I also want to say that for those who are interested to read the cases that I made reference to, those who are interested to look at the Maputo Protocol or even CEDAW and other protocols that South Africa has ratified, we are going to package that information and share with you. And in that, I want to thank you very much for your time and the opportunity to share this information with you. Thank you, Lynn.
Thanks so much, Wele. We just have one last comment from Deline. I'm saying this, I hope I'm saying this right. Deline or Delian Clark. And they say the information was really informative and well presented. So thank you very much, Wele, for that. Thank you so much for today. I think even for me, it was very informative, and I learned a lot as well and refreshed a lot that I hadn't really been face to face with in quite a long time. Thank you so much to everybody who's joined us today and this afternoon. Thank you for taking the time out to come and be a part of the session. Each week we're learning more and more. Each week we're getting more and more engaged, and we're becoming more and more familiar with the content and the processes around the National Strategic Plan on Gender-Based Violence and Femicide, our NSP, as our hashtag goes. So continue to join us. We'll be back again next week. Next week we'll be talking about, which is week 7, we will be talking about the National Council structure, which is a very, very important part of our conversation. So you don't want to miss out on that. We will be live streaming it on Facebook again, or you can also join us on our go-to webinar. Please do register. I think on our Facebook page as well as our Twitter page, we have where you can actually go and register there. Our Facebook page, just as a reminder for those who don't know, it is Call to Action Collective. That's where you'll find us. You can like us and join our page. On Twitter, you can find us at Call to Action ZA. That's where we are as well on the socials. So we don't have any more questions or comments for today. If there's anything else that comes up, both on GoToWebinar or on Facebook, we will collect those, respond to them, and send them out to you. A final reminder about our surveys that we send each week with your the same email that comes with your registration. Please do go ahead and just let us know your part of this process, how you think it's going, and anything else that you think will be valuable to us as we go along each week. And then so from me, Lindelo, thank you again for joining us, and look forward to having you again next week being part of the conversation. Thank you very much.